Today I'm going to briefly explain the law relating to replica furniture, if it is legal in Australia to sell replicas, and how that compares to the evolving legislation in the United Kingdom. Take our mate Joe here for a second. Joe is sitting down, having his morning coffee in his uncomfortable and ugly chair. This gives Joe the fantastic idea of a new chair design. He has no idea if anyone else would appreciate his unique and new chair design, but he starts manufacturing them, and suddenly they're selling like hotcakes. Hooray, Joe is going to be a millionaire, all because of the Joe chair. Perhaps not if Joe happens to live in Australia. In Australia, it is legal to advertise furniture as a replica. This is because replica furniture is often copies of designs from the 1960s or 70s, where copyright protection has expired or was never in place. However, even copyright protection available today is still very limiting. Section 10 of the Commonwealth Designs Act allows designers to register their design to gain exclusive rights. This prevents others from making, selling, offering to sell, or importing a design that embodies the registered design. However, the designer must register a design before it is offered for sale or manufactured to the extent where it would be considered to be applied industrially. The term applied industrially has the meaning given by the regulations under Section 77 of the Copyright Act. The Copyright Regulation 17 specifies that, for the purpose of Section 77, a design is taken to be applied industrially if it has been applied to more than 50 articles. Assuming that Joe has sold more than 50 Joe chairs, the Joe chair is no longer considered new and Joe has lost the ability to register the design. This means the Joe chair can be legally copied, allowing Jim or John to come along and sell replicas of the Joe chair to the Australian public. Even if Joe had the foresight to register the Joe chair under the Designs Act, his registered design would only be protected for 5 years and another 5 years upon extension. This is less protection offered to architectural works which are covered by copyright laws during architecture's lifetime and 70 years after their death. Poor Joe could have copyright protection, but he needs to be careful relying on this protection as it may not apply to the design industrially, but to the drawing of the design itself. This automatic copyright is lost when Joe registers a design industrially, as dual protection is not possible, therefore losing the lifetime plus 70 years protection under copyright. The UK are extending their design protection laws, which were planned to be introduced by 2020, but brought forward given the detrimental impact it has on designers. The new laws will allow for artistic craftsmanship to have the same coverage as painters and sculptors, with registration lasting the lifetime of the designer plus 70 years. Furthermore, design protection laws now ensure copies and replicas are considered illegal, with fines of up to £50,000 and 10 years jail. UK's change of legislation is to bring the country in line with EU IP laws. These necessary changes don't appear to be on the horizon for Australia. A recent review by the Australian Law Reform Commission was seen to go further to protect Australian replica industry more than the creative industry. Australian lawmakers need to place more importance on protecting industrial design and supporting the creative industry, including poor Joe.